Every now and then I see something on the news that just really bothers me, and that's the case today. Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. And today we're going to take a look at some ethical rules that govern lawyers. We're going to take a look at some allegations that have been made in a lawsuit. We're going to take a look at a response to some of those allegations that were made in the media. And then I'll have just a few comments on all of this. Trevor Mullinax is a guy who lives in York County, South Carolina. And in 2021, he had a warrant, a felony warrant, for some violent crime out of York City, South Carolina. Once he knew that he had this warrant, he grabbed a shotgun and a knife and got into his pickup truck and told everyone who would listen, I guess, that he was going to harm himself. This is not a good thing. And as a result, his friends, trying to do the right thing, called the 911 center and asked for a sheriff's dispatch for a wellness check on somebody who was having a bad day. And of course, they mentioned the person's name. The 911 folks ran the name and came away with a felony warrant out of York City. So the police officers, or I should say the sheriff's deputies who were arriving, knew that they had a felon because he had a record, and that he had a shotgun, and that he was having a mental health crisis. And as a result, when they showed up, they immediately stepped out of their vehicles. They drew their weapons because they were making a felony stop, a felony arrest. And when you make a felony arrest, it's reasonable to presume that the person that you're arresting is armed and you have a need to protect yourself. And so they told the man to show him his hands. His mother was standing next to the truck, but they didn't know she was his mother. And when they saw the shotgun come up, because he grabbed the shotgun and pulled it up, they opened fire. They hit him 9 times. They got him to the hospital and he survived his injuries, and now he is filing a lawsuit. They held a press conference the other day, and in that press conference the lawyer went through some of the more salacious facts that are contained in the lawsuit itself. One of the things that they said, for example, was that the officers just showed up and opened fire without warning, which is incorrect. They said that he was in lawful possession of the shotgun, which was incorrect. They said it was a hunting shotgun. Perhaps that is true. However, you can't tell what kind of shotgun it is from a distance. Any kind of a shotgun can hurt you or kill you. And so the officers, I think, were reasonable in discharging their firearms in this case. And it's a wonderful thing that the gentleman survived. But now his mom and him have filed a lawsuit against the York County Sheriff's Department. That is not the source of my problem in this case. The source of my problem in this case is the pre-filing lawsuit to detail the results of their investigation and the impact that it's had on the Sheriff's Department and the community, giving you some indication of whether it meets or exceeds the requirements of the rule regarding trial publicity. With no further ado, let's move right into taking a look at the ethical rules that govern trial publicity for lawyers. This is Rule 3.6, which is found inside Rule 407 of the South Carolina Rules of the Bar, and it governs trial publicity. It says a lawyer who is participating or has participated in the investigation or litigation of a matter. So it's any lawyer who has been doing an investigation or who has filed litigation or knows that they are going to file litigation, shall not make an extrajudicial statement. That means a statement outside of court. And in context of this rule, it also means a statement to the media that the lawyer knows or reasonably should know will be disseminated by means of a public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Notwithstanding that, the lawyer can state the claim, the information contained in a public record, and that an investigation of a matter is in progress. Those are the rules that govern. What the rules are essentially saying here is you have to be careful what you say in public as a lawyer, because if you say too much, you risk prejudicing the judicial outcome. Basically, by creating so much anger and antipathy against the defendant, or in some cases the criminal defendant, that they cannot ever possibly get a fair trial. Now, in addition to the rule that we just went over, there is another rule that deals with what an attorney can say and, more importantly, what he can't say with respect to the truth. And essentially, it says you can't lie to third persons. Let's take a look at that rule. This is Rule 4.1, Truthfulness in Statements to Others. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. Now, the second part there doesn't really apply because there's no criminal or fraudulent act in this case. Okay, everybody understand the rules here? You can't make a statement about the case that you're going to try out in the media if you think it might unduly prejudice the people who might have to sit on that jury, right? And at the same time, you have to be truthful. And similarly, you have to be truthful in your recitation of events in the complaint. We went over Rule 11 the other day in the federal rules, which require truthfulness in pleadings. Every state has a similar rule. You can be sanctioned if you plead things that you know are false. Now, obviously, sometimes you plead things on information and belief that don't turn out, and that happens. That's what the investigation and discovery are for. But at the bottom line, you should try very hard to make sure that everything that you say is accurate and complete. And that's especially true if you are going to rely on the idea that you can tell the media what the claim is. To me, a media statement about a claim is, we are filing a lawsuit against person A, and the subject of that lawsuit is negligence, or it's wrongful death, or whatever else it may wind up being. That's how you satisfy the trial publicity rule. And then when reporters pepper you with questions, you say, I try my cases in the courtroom. I do not try them in the court of public opinion. Please come to trial. Please report on my trial. But I can't make any further statements about this other than letting you know we filed a complaint in the circuit court today. So this is the complaint that was filed, and it says that he was suffering severe emotional distress stemming from personal relationship issues and was contemplating suicide. That's incorrect. He had a felony warrant, and his emotional distress was about going to jail. He did not want to go to jail. That's what he told other people. Then they essentially, this could be an oversight on their part, or perhaps they don't understand the criminal law of the South Carolina or the Federal Gun Control Act of 1968, but they claim he was lawfully in possession of a hunting shotgun during this time. It wouldn't matter whether it was a hunting shotgun or a tactical assault shotgun. A shotgun is a deadly weapon, and there's no way to look at a shotgun and say, oh, well, clearly that's for bird hunting, and he just happened to have it in the truck. In fact, the entire time Plaintiff Beeson was talking to her son, the shotgun was present. So he had that shotgun for a reason. He never intended to use the weapon on anyone other than himself. No way for the deputies arriving to know that. They claim that the 911 operator failed to provide the cell phone number so that they could attempt de-escalation. Well, again, they don't know that there's anything to de-escalate until they get there and see a shotgun. Sheriff's deputies, despite obvious lack of training or woefully insufficient training, made no attempt to contact a mental health care professional. Prior to arriving at the location on the property where Mullinex was sitting inside his pickup truck, Sheriff's deputies drew their firearms and were prepared to shoot plaintiff. In fact, you can see in the badge cam when they get out of the trucks that they come in, that's when they actually draw their firearms. And keep in mind, they are making a felony stop. They believe that they are going, among other things, to arrest him for a felony warrant because he has a felony warrant out of York City. But instead, the plaintiff says, choosing instead to ride in like cowboys from a John Wayne movie, defaulting to using deadly force. That's what they do. And then they jumped from their sheriff patrol vehicles that were still in motion, immediately pointed their loaded department-issued firearms at Mullinax and as well as at Beeson, immediately and without warning, justification, authorization, or affording plaintiff time to react. Sheriff's deputies began firing their weapons at the Mullinax's vehicle. So is this the full story? Of course not. You don't, if you're a plaintiff, you don't plead the other side's defense. What you do is you set out the facts that you think give you the right to make a claim. So there's nothing wrong with them doing that as long as they plead them carefully and accurately. And as I pointed out, I don't think they did that in this case. Now let's take a look at the actual encounter. It's a very short video clip, and as a result of that, I'm not gonna play things that I think would cause YouTube to have a problem with this video.
Hands! Let me see your hands! Let me see your hands!
So as I went over, the complaint has a lot of inaccurate information in it. And I think the press conference also had a lot of inaccurate information in it. And I think it's worthwhile to listen to what the sheriff says the real facts are as uncovered by the South Carolina Law Enforcement Division, as well as what the impact has been on him and his department.
What I am going to do is simply state the facts that were uncovered during SLED, the state law enforcement's independent investigation into this incident. And I want to point out that every officer involved shooting that we've had under my command, and I've had 9 in 6 years, every single one of them has been investigated by the state law enforcement division, not us. We do an internal review to ensure that no policies were violated, but the criminal investigation is given to a completely independent agency to investigate. So, on May 7th, 2021, we received a call for service in reference to a well-being check on Trevor Mullinax, who had expressed suicidal ideations and was armed with a knife. Dispatch informed responding deputies Mullinax had active arrest warrants through the York Police Department for a violent felony as well as malicious injury to personal property. When we responded to the location, we found Mullinax sitting in the driver's seat of a pickup truck and a woman named Tammy Beeson, who we later identified as his mother, standing outside the closed driver's door. The deputies were dressed in their uniforms and arrived in 2 York County Sheriff's Office marked patrol vehicles and provided verbal commands for Mullinax to show them his hands. In her interview with SLED, Tammy Beeson stated that she saw Mullinax reach and grab a firearm when deputies arrived at the truck. Ms. Beeson stated specifically in her interview with SLED that Trevor Mullinax, quote, reached and he grabbed the shotgun and he pulled it up, and that's when they, meaning the deputies, saw it and started shooting. Deputies state that they saw Mullinax with a firearm in his hand, and all 4 deputies discharged their department-issued firearms. Mullinax pointed and or presented a firearm at the deputies from inside the vehicle when they encountered him. Mullinax sustained multiple gunshot wounds and was transported to the hospital, where he informed medical personnel that he wanted to shoot himself, but then decided to have the police do it, and he grabbed the gun when we arrived. Mullinax is prohibited from possessing a firearm or ammunition pursuant to the Federal Gun Control Act of 1968. Mullinax was charged with pointing and or presenting a firearm by the South Carolina State Law Enforcement Division, not the York County Sheriff's Office, as a result of their investigation.
Now, there can be a legitimate dispute about the accuracy of the facts and the way they were presented in the complaint. That's what the court's for. There could be things that come out in depositions that paint the sheriff's office in a poorer light, and there could be things that come out in depositions and other statements that indicate that Mr. Mullinex was more than just having a bad day, that as indicated, he had some prior problems with law enforcement, and there might have been other things at work here. Either way, the issue that I have is that the information presented to the public should not have been presented based on the trial publicity rule. Listen to how this has impacted the sheriff's office.
I feel forced to address this suit out of what I consider to be the proper venue, and that's court, because Mr. Mullinex and his attorneys decided to call their own press conference to disseminate selected information about this incident to the public. Now I have people from all across the country calling and emailing people in my office saying things like, "I hope you get cancer. You all should have been abortions. I don't know why you haven't committed suicide." And me personally, I've been called an anti-American pig.
To be fair, here's what Trevor and his mama said.
They destroyed everything that I believed in that day, and it has taken me a very long time to try and recover from that. I'm still recovering. It's hard to live in this county where this happened at.
If it helps even one single person in this world to not have to go through what me and my family have, I'm okay with it.
I don't practice law in South Carolina, so I don't have a dog in this fight. I will say this. If I was that sheriff, I would be filing a complaint with the state bar, because he has violated both the spirit and letter of the trial publicity rule by holding this press conference and by pleading things that he knows, or in the exercise of a reasonable investigation should know, are factually untrue. And so I would file a complaint with the bar. And I think that's how you deal with this. And lest any of you think that this is somehow just, his reaction to this very bad case and he wanted to talk about it, let me show you a couple of things from his website. After paying lip service to the rule by saying the media should never be utilized solely for attention or to cause public uproar, he says, instead, we take advantage of all available channels to correct false narratives established by parties on the other side, draw attention to key policy issues to minimize the chance of repeat incidents occurring in the future, and fight to achieve the maximum compensation possible on behalf of our clients. I'll let you evaluate whether or not it was an accident or an intentional act. Let me know what you think in the comments. Thanks for being here. Thanks for watching. If you have the opportunity today, go out of your way, do something nice for someone, and catch me down here at the beach next time.
Please hear me, and I cannot say this more clearly than what I'm going to say. If a suspect pulls a weapon on a man or a woman wearing the badge that says the York County Sheriff's Office, that situation is not going to end well for that suspect.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.